I will speak on three parts. First, I will share with you some specific challenges and lessons learned with mediation in cross-border family disputes based on my experience of the last 15 years. Then secondly, I will say a few words about what Brussels II recast says about mediation. And last but not least, some words on what the recast says about cooperation between central authorities, courts, and mediators. What are achievements and what are weaknesses of this Brussels recast in this regard? And I will end with some conclusions and recommendations, and I give you some further reading if you want to continue on that subject. So first, I would like to share some challenges that I find are very specific challenges in cross-border family disputes from a mediator's point of view. The basic challenge actually is the question, how can we actually support parents to ensure the child's best interest, according to Article 3 of the UNCRC, in a context where the parents are already in a situation of personal crisis due to divorce and separation. And in addition to that, what everybody else has, cross-border families or multicultural families have the challenge of geographical distance, of cultural differences, of language barriers or multi-language environments, and of what we're here for today, for very, very complex legal environments. And on top of that, when we talk about wrongful removal of children, we have this word child abduction, or sometimes even child kidnapping, which is really coming from criminal law, from penal law, and which is symbolically very much loaded in common comprehension. And so it's often adding fuel to the fire. So what I would like to say is that the specific challenge is actually that a parental conflict gets very often amplified by the international context. And our colleague Gianpaolo Romano already also mentioned things in this regard. What are some of the lessons that I have learned in the past 15 years doing mediations and counseling in those cross-border cases? Well, the first lesson for me is that there is a huge difference, a world of difference, if we may say, between legal facts or binary interpretations, what is a wrongful removal, what is an abduction, on one side, and interpersonal relationships on the other side. The legal reality is very often black or white, and the human reality is more like 50 shades of gray. Second lesson learned is that, and this might be surprising, but in my experience, actually meeting with each of the parents, even the taken parent, the abducting parent, actually, I found out that they always want the best for their child, but they have diverging interpretations of what the child's best interest is. I give you two examples. One of the classical examples are the taking mothers that are very often taking the children in a context of alleged domestic violence. If you interview them, and Gianpaolo Romano talked about Mrs. Neulinger, if you talk about with any of those mothers, of course, they will tell you that they are really acting in the best interest of their child, in their personal conviction. In another case, I would like to mention to you is the Algeria case. We had a few years ago in International Social Service, a classical child abduction case to a non-hate country, which was Algeria, where actually an Algerian father abducted the two girls, very young age, 3 and 5 year old, because he was personally convinced that those girls should not grow up in a European Western environment. He told us that in the mediations that he was just convinced that it was not in their interest to become adolescents in Switzerland with all the Swiss boys dragging them and running around them. So he was convinced that they should be protected, living in Algeria with him, his new wife, and in a village environment in the Algerian backcountry. So that's really the subjective interpretation of the child's best interest, which varies from each parent, but they both base their action actually on the child's best interest. This brings me to the question, when do abductions actually occur? In my experience, there is a series of points, and in one of the literature that I mentioned to you, that you have longer lists of that, which have also been found in research. But just from my personal experience, you know, one motivation for abduction is a subjective feeling of unfair or unequal justice system. So we're talking about a parent who is presuming that actually the judge of the country of habitual residence would have a gender bias or a national bias and would give a preference, you know, to the other parent, which is a national of that country, to the disadvantage of the parent who is actually abducting the child. So it's just a fear that the justice system is not fair enough to both of them. Then there are lots of cases I have seen where parents actually abduct a child because they feel humiliated or dishonored by a local court or a child protection authority. In a case with Guinea, which I had, we had the specific situation of family, mother from Sierra Leone, father from Guinea, both living in Geneva with 5 children. And the parental conflict was extremely high. And at a certain point, the Child Protection Authority threatened the parents to outplace the children in a foster home. Okay. And when this threat was placed upon the father, his honor was just attacked completely frontally. And the only remedy that he found to reestablish his honor as an African patriarch, man, you know, family chief, was to abduct the children to Guinea, excuse me. I will tell you later on in 1 minute what we did with that case then. But that was actually the motivation for the abduction was, you know, the father just felt humiliated by what the authority actually told him and was planning to do. And then, of course, we have the very frequent motivation, especially in hate cases, where a parent fears for personal safety or for mental and physical well-being. And in that context, also, we have the phenomenon of domestic violence. So we have really those abductions that are not, you know, easily decided, that they are decided upon very, very heavy personal sufferings. And only, you know, at the end of a long journey of suffering, mental, physical, emotional, the abduction actually is decided and occurs. So just to, you know, to put that on the point at the end, I have actually never, I put here rarely, but I honestly have never seen, you know, that somebody just, you know, takes the child as a revenge against the other parent, or with a criminal intention. I mean, there are cases of criminal child kidnapping. That's something very different that I'm talking about now. But in the parental child abduction cases, the motivation of really just, you know, damaging the other parent is something that, you know, shows up in legal proceedings. But when you really work as a mediator with those parents, you don't find this as the bottom line. So what can mediation do in those cases? And that brings me to the second part of the lessons learned. Mediation can acknowledge those differences between the parents. Mediation can work out what common values are between the parents. And, you know, luckily enough, in family mediation, we always have a common value between the parents, as much as they might be in conflict. And this common value is the child's best interest. You can always bring the parents back to this common value. You can acknowledge the subjective feelings. What happened in this Guinea case, just to give you the example, is that this father was actually completely isolated in Geneva. Nobody from the official institutions actually talked with this father. He was very badly seen. And when he contacted ISS, International Social Service, we just asked him, would you allow us to talk to you? And I invited him into my office and I spoke with him. And, you know, it was, I think, probably the first time that he felt respected in his subjective feelings, in his personal honor, with all his status that he has. And from that on, we were able to set up a mediation between the mother and himself. And at the end of that mediation, 2 months later, he agreed to bring the children back to Geneva from Guinea, which was a long administrative and complicated operation. What mediation can do is mediation can really refocus the parents on the children's needs, you know, and what the children's interests are in that situation. Mediation can empower the parents in their co-parenting capacities. And what mediation can do is it can really work out tailor-made solutions for every specific family. And just to give you another example of this Algerian case with these 2 young girls that were abducted to Algeria, in that case, which was taking maybe 2 years for working out a solution between the parents, the solution that the parents actually found through a very complex mediation case implying different family members was that the father agreed to bring the girls alternately back to Geneva for longer holiday periods 2 or 3 times a year. So he actually decided to keep the girls permanently in Algeria, and the mother had no other legal means because there is no Hague Convention, there was no interstate cooperation between Switzerland and Algeria. The mother had no legal means to, you know, force the return of the girls, but in mediation they found this agreement that alternately the girls can spend time with their mother and with their half-brothers and half-sister that were born out of a second wedlock with the mother in Geneva. So mediation there was really capable to work out a very, very specific solution which nobody would ever have dreamed of or been able to invent if it had not been the family herself. If you want more information on this case, there's a whole book that has been made out of this case with a detailed description of the whole family story, the whole abduction story. It was a research project from Neuchâtel University in Switzerland with a whole book in French about this and another case with Sri Lanka abduction. Okay, so this brings me to the second point. What does Brussels II recast say about mediation? I will speed up maybe a little bit. The preliminary paragraphs say a few things, namely that in all cases concerning children, and in particular in cases of international child abduction, courts should consider the possibility of achieving solutions through mediation and other appropriate means, assisted where appropriate by existing networks and support structures for mediation in cross-border parental responsibility disputes. Such efforts should not, however, unduly prolong the return proceedings under the 1980 Hague Convention. Moreover, mediation might not always be appropriate, especially in cases of domestic violence. I will skip the second preliminary paragraph, just to draw your attention on the wording. So the text says here that authorities and courts should consider and should assist. So it doesn't say shall, it's not mandatory in that wording. And what I always also would like to underline is that you feel very strongly in this text the fear that mediation can be misused for unduly prolonging the return proceedings. We cannot go into depth of this fear. I would put some question marks under this general suspicion that we feel in some of those texts in The Hague and also in Brussels that mediation can be misused. Of course, I'm aware of this danger, but I would put some question marks on that, but we don't have time for that. So in the main articles, there is basically Article 25, which is headed Alternative Dispute Resolution, ADR. And I would like to cite this article. As early as possible and at any stage of the proceedings, the court, either directly or where appropriate with the assistance of the central authorities, shall invite the parties to consider whether they are willing to engage in mediation or other means of ADR, unless this is contrary to the best interest of the child, it is not appropriate in the particular case, or would unduly delay the proceedings. So again, here we have something a little different. We have courts or central authorities shall invite. What is mandatory here is not mediation in itself. What is mandatory is the invitation to consider, okay? And if you look at it closely, it says actually should invite parents to consider whether they are willing to engage. So what we have here is, a very, I would say, a little bit frightful knocking on the door. Would you be maybe willing to think about, so it actually anticipates a bit the possibility of an uninformed parental refusal, a parent that may just say, no, well, I don't really like to hear about mediation, but it would be uninformed because, it would only have been an invitation made by the court, and it would not have been an actual experience of mediation made in a mediation, for example, in an informative mediation session. This brings me to the point, that I think a minimum requirement would have been, from my point of view, a mandatory mediation information session run by experienced mediators. So parents would actually be able to experience, to hear from mediators what mediation can offer, and maybe get a first sensation in a first session of what kind of advantage mediation can bring to them. And I would just like to refer to best practice we have in this regard in the Netherlands with, mandatory mediation, and also to some extent in Germany. And I'm happy to know and see that colleagues from MIC and from International Social Service are also here today. There is Article 79 that mentions specific tasks of requested central authorities. It has already been mentioned also by former presentations. So the paragraph G says that requested central authorities shall facilitate agreement between holders of parental responsibility through mediation or other means of alternative dispute resolution, and facilitate cross-border cooperation to this end. So here again, we have an obligation to shall facilitate something. And I see personally, not being a jurist, but maybe you have more clear opinion about that. For me, it's a little contradictory with Article 25, which does not put such an obligation actually on the central authorities. Maybe just a word, I see that time is running, so I will make it short. Just to mention that in Switzerland, we have the Swiss Federal Act on International Child Abduction with the two articles 4 and 8 with a different wording. In Article 4, the central authority may initiate mediation, and under Article 8, courts shall initiate mediation or conciliation, which makes an obligation in Switzerland. So both Brussels II recast and the Swiss Act have, what they don't have is they don't have a mandatory mediation setting prior to court proceedings. And I come back to what I mean by that. A word on cooperation between central authorities, courts and mediation. We already have seen what kind of cooperation is requested in terms of mediation. What are, in my views, achievements and weaknesses? And I have 1 more minute and then I'm finished. What is an advantage of progress, I think, is that Brussels IIter clearly promotes mediation and ADR. We have seen the articles. And it also promotes clearly cooperation between central authorities, courts and mediators. However, what Brussels II recast, in my eyes, does not do, it does not create a mandatory mediation setting. And I would just like to refer to what we have in Australia, in domestic family law in Australia, with the family relationship centers, where actually all divorcing and separating parents all over the country in Australia are obliged under the Australian family law since a bit more than 10 years, 13 years, to actually go to a family relationship center, be counseled and mediated there in the presence also of legal advisors, if requested, before they get access to the legal procedure. So that's what I call a mandatory mediation setting that would be prior to the procedure. Of course, we would have all the challenges with speed, with timely proceedings under Hague and Brussels II recast. But we do have experience with that. We have experience in the Netherlands, we have experience in Germany. So this is not an impossible task, but for me this is clearly lacking. And what is lacking for me is in Brussels recast a full understanding of the potential of mediation in cross-border family disputes. This brings me to my conclusion and recommendations. So Brussels IIter makes important general progress in including ADR and mediation in its legal framework. However, it leaves too much space for parental refusal to engage in mediation setting. Remember, whether they are willing to engage. For me, this gives too much power to the parents. And Brussels IIter does not make full benefit of successful international experience with mandatory mediation settings in cross-border family disputes and or domestic law. So I would suggest, in the best interest of the involved children and families, that a binding mechanism of mandatory and timely mediation be created in cross-border family disputes prior to court proceedings. So this is my contribution. Here you see some further reading. I put some articles on it. I put the main book of Mick on it, and some links to international family mediation guidelines that International Social Service has worked out. The link to the International Family Mediation website created by International Social Service, and the link to the MIC website of the German NGO MIC, which is doing great work also in this area. Thank you very much for your attention.